Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she goes, "Oh, girl, you gotta hear this one. A man was arrested for running a theme park, and when they said, 'Where's your license?' he said, 'My dog ate it.' Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, 'I've been through hell and now I need some help.' You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
All right, y'all, here we go. We've got the full March document drop from the Tyler Robinson case. It's got a lot of the defense versus the media, as we've seen in the past, but it's also got a motion for a continued of the preliminary hearing from the defense, which has some interesting info in it. And there's been a lot of stuff in the media this past week or two that is talking about this bullet evidence. Well, we're going to do today what we do best around here and take the media headlines and rip them apart and tell you whether they are lying or not. Because when you actually sit down and you look at what the motion says compared to what the media is telling you, they don't measure up. And once again, the media puts their little drama spin on it. And that is just what this case needs, is just even more conspiracy theories. And what do we hate around here? Conspiracy theories. Because there's always three sides to the story. My side, your side, and the truth. And around here, if it ain't in the documents, it's not the truth. And then sometimes even the documents leave room for some desire. However, remember, one of Tyler Robinson's lawyers is Kathy Nestor. And if you are unfamiliar with Kathy Nestor, she was Corey Richins' lawyer, and she is a hot mess and a half as a lawyer. So buckle in, grab a drink, hold on to your hats, and we're not here for the headlines. We're here for the actual information. We read the documents and shift the narrative back to the truth and the facts and not the sensationalism that gets clicks. All right, y'all, let's say hi to the chat. Who hope everybody is doing well. Sorry, I still have good old, the good old allergies, so I will do my best to not cough on camera or mute myself, but we all know how well that goes. Gail, good to see you. Yes, Heidel, thanks. If you like this channel, but you think I'm a little too much in your face, try subscribing to my other channel. That is my professional channel where I use my certifications and we talk about things like chronic pain, fall prevention, and I actually use my college degree to help you and keep you out of the medical industrial complex, whereas here we just rant, rave, and call people stupid. Um, However, if you like a little bit of a more professional and softer side of me, that channel is for you. And yes, get F-bomb. F-bomb. This line in the middle of my forehead, I do not have a filter on my camera or on StreamYard. This little line in the middle of my forehead, I'm looking at myself on camera, is starting to go away. And these lines, they're doing their thing. Because of this, as F-bomb, this is Beef Tallow skincare. I am addicted to it, like addicted. I use it for everything from my cuticles and nail beds to my face, to cracked heels, to skin tears and my rough looking CrossFit hands. It's a miracle worker. If you go to their website, thetallowtooth.com, and use code SQUID, you get 15% off. God love it. I am addicted. And there's not very many things that I'm addicted to, and there's not very many things that I will tell you that I'm so addicted to it that you have to try it too. But this is one of them. And it's called F-bomb. I mean, come on. Is that not me? Like, is that not my personality wrapped up in a product? All right, Gail, good to see you. Steven tells Squish she can start now. You're here. It's not that I wasn't on time. It's just that Mama Bladder had to relieve herself, and we had to do some mama stuff. Otherwise, I'd be running to the bathroom halfway through this stream. French Psycho Tammy. Oh, you changed your name. You're not going. Are you ever going to change it back? Jeffrey, Gail, after all the cat jokes, you're ready. King Bob, good to see you. Oh my goodness. Snipe Hunter, good to see you too. Andrea, and sorry if I'm missing anybody. You're lurking, Big Papa. Good to see everybody here. We are going to get into this. Curbless, how are you? Squid doesn't have a filter on her mouth either. You know. Yeah, you'd love it here today. A high of 78, low of 37. Yes, it's a 40-degree drop between 7 p.m. and 2 a.m. Welcome to my world. It's 40s at night and 80s during the day. But that's March through May here. All right. Hey, Sebastian, how are you? All right. Sorry if there's anybody I miss. Lurkers, please hit that like button or don't. But I'd appreciate it. It helps YouTube say that this isn't a drama stream. We are not talking conspiracy theories here. We are trying to break through the conspiracies and actually get to what matters. And just a little shout out to the person who is the reason that this stream is able to exist, and that is Andrea Burkhart. All of these documents came from her Substack. She is the reason that all of these exist. She has been posting them on her Substack, and I pay to see her Substack instead of paying the government. I would rather support her. If you do not subscribe to her Substack or her YouTube channel, fix yourself and go do that, because she's an awesome, awesome person. And she's one of the few lawyers that I would actually trust on YouTube. Just saying. All right. So the documents that did come out in March. Excuse my lack of ability to speak English all of a sudden. There were just a lot of motions for there's just a lot of motions for, and I had this up on my laptop, so I'm going to open my other computer so we can organize this. Like I said, I had to use the bathroom, so I didn't open my other my other documents as much as I wanted to. But the most of the month was just the media and the defense team going back and forth on should the media be allowed in this preliminary hearing that is tentatively scheduled for April 17th. However, yes, more watch time and keep thumb to keep squid on YouTube. Thank you so much. Thank you so much. And I do have to go into this and just, there we go. So I have one computer open here, 2 screens here. We are slowly increasing the amount of screens that I am looking at. And if I wasn't confused before, I'm going to be now, because Lord help me, it gets confusing. Oh, 12 likes. Thanks, guys. There's 24 of you here. There's 12 likes. Appreciate you. Appreciate you. All right. So, starting, there was, let's see, preliminary hearing set on 5/22. Then there's request for electronic media coverage for court proceedings, of course. Then there was news media's motion to classify, opposing motion to classify. Then there was news media's supplemental memo opposing motion to exclude cameras. And we're not going to get into these because it's the same thing over and over again. The defense wants to keep the media out because they want to keep Tyler Robinson private. They're claiming that he won't get a fair trial because of all the publicity, blah, blah, blah. Like, he is the only MFing person to ever be a high-profile defendant in the entire world. Poor me, poor me, poor me. Don't care. Ask Sarah Boone how that went for her. It did not. Welcome to courtrooms in 2026 where we have cameras. Suck it up, Buttercup. I got nothing for that. This is called transparency, and the defense does not like it. Then there was the state's response to defendant's motion to close portions of the April 17th evidentiary hearing. It was all, we're not going to get into those because it's just the same arguments over and over again, and we don't have time nor the patience with this defense team to tolerate the fact that they want to hide this evidentiary hearing. Suck it up, Buttercup. Tyler Robinson is not the first high-profile defendant to be on camera during his hearings and his trial. Suck it up. You don't like it? Too fucking bad. Maybe you should find a different job. Yes. Poor me. Poor. That's. I have no. I can't find any. When defense teams do this, it's. I want to hate the government so much. I want to hate the government so freaking much. But when defense teams do this whiny bullshit of, we can't have cameras, we can't have that's what that is what voir dire is supposed to be for a jury. If you cannot find an impartial jury during voir dire, that's a you problem. That is not the result of the cameras. That is a result of you not asking the right questions during voir dire. To say, I don't think, after the Corey Richards trial, I don't think she'd want to be seen either. Because she didn't show herself to be a very skilled litigator. And lawyers might be great. There are certain skills. Like, let's go in the Wayback Machine to Amber Heard. Elaine might have been great at negotiating settlements, might have been great at what she was good at. And lawyers need to be great at certain things like that too. However, being in a courtroom is a special skill set. Certain people have it and certain people don't. Kathy Nestor is one of those people who just does not. Kathy Nestor is the Elaine of 2026. It's bad. It's bad. I mean, to be fair, I really don't want to see her either. Okay, so I didn't watch all of the Corey Richards trial because, life, I can't sit down and to watch all of it. But what I did see when I was in and out of most streams, secondhand embarrassment. I get secondhand embarrassment for people. I had secondhand embarrassment for Kathy Nestor. And knowing that she was Tyler Robinson's attorney made this, I don't know if this made it more entertaining or more cringy than it already was. Because it's just cringy on a level that just cringy. Like, you just can't. Cringy. So the one thing we will read through, though, is there was a notice of restitution for Tyler Robinson with a victim, Olivia Hobbs. I have no idea who this person is. I had never heard that name before. But it's a criminal case. In accordance with the provisions of the Utah Office for Victims of Crime Act, Utah Annotated Code 63M-7-519, Utah Office for Victims of Crime hereby gives notice that the state of Utah is subrogated to all claimant victims' rights to receive or recover benefits or advantages for economic loss. The following expenses or losses incurred by the victim claimant have been reimbursed by this office to date. Mental health therapy, $115. And I have no idea. I have no idea exactly what that was referring to. It doesn't really go into a whole lot. However, I just thought that was interesting that was in there. And that's one of the documents that really hasn't been talked about. And you will never, ever hear talked about because it doesn't bring drama. Holy absolutely, what the heck. Hung Hero, thank you for the 50 Squid Pro Quo memberships. 50. And I have to open up my my YouTube studio to see exactly what that went to. Oh, look at all those people. I am popping out the chat. Oh, look at all those people. Oh my goodness. Like, y'all, if you received one of those gifted memberships, please thank Hung Hero. He and a few others are working to keep this chat green. Stay green, chat. Love ya. Oh my goodness. Whew. I don't know. Like, I appreciate. And I have to say it because it's in a super chat, but I'm going to clutch my cross while I do it. Hung Hero, thanks for the $5 super chat. Don't be a half-cut get green chat. Holy goodness. Okay. Oh my goodness. All right. Well, that just made my day. Thank you. I appreciate that so very, very much. Oh, all right. Back to the we do have the motion or the order for the classification of court records. So this is from the judge. All right. Rulings and orders on classification and closure motions. Judge Tony Graff Jr. Before the court are 3 motions to classify court records. Defendant's motion to classify as private, filed January 9th. Defendant's motion to classify, motion to exclude, and defendant's motion to classify in reply in support of motion to exclude. There's 400 docket entries in this, or over 400 docket entries in this trial already. It's just, yeah. Oh, sorry, I've been scared. His wife started the first round of IVF, been keeping me busy, keeping her comfortable. Good luck. I hope everything works out for the best. If you are the praying type, pray for Mrs. Ungung Hero. She is starting IVF, and we hope she's a soon-to-be mama. So we hope that they will be expecting. And Sticky Widget, hey from Vienna, how are you? Hey, member for 14 months. It's been that long. Jeez. Hello from Vienna, Austria. How is it on the other side of the world? And I feel like I should ask you this too. How is it on the other side of the world? How is the future? All right. The public has a presumptive right to access court records. See Utah Rule of Judicial Administration 4-202-0.02. See also that case law. Open court records assist in educating the public about the workings of government and the decisions being made on the public's behalf. Contribute to informed debate. This is my biggest thing right here, informed debate, because we have millions of people in this country who, one, still believe the headlines when they've never actually read the court document, and the headlines are lying to you or giving you half-truths. So in order to be informed, you actually have to have access to the document, which is why, although sometimes reading court documents is boring AF for some people, it's why we do it. Because it leads to informed debate, and we don't cherry pick. We put the whole document up there. Yes, I kind of skipped through some of the, like, we're not talking about that. That kind of stuff. However, it is good to be informed on things. It's why we fact check the media, because they are bullshit. And there's a faction of this country and the world that believes that the media still has our best interest in mind. No, they have their wallets in mind. That's it. They have clicks and views, clicks and views, clicks and views. And yes, clicks and views are nice for my wallet. I will not lie. However, that is not the main focus. If I wanted to get clicks and views, I would talk about one subject every day because it gets the clicks and the views. However, there are other things that are more important than just clicks and views. And it's this. Allow the public to hold public officers and employees accountable. Increase public confidence. There's another one. We don't trust the government, so we need to know that the government is doing the right things. And provide material for independent research on improving government policy. The right of access, however, is not absolute. Other factors may favor closure of records, such as protecting personal privacy, non-parties participating in the court process, and a defendant's right to a fair trial. Footnote, the media has filed a request to submit on its motion to classify supplemental memorandum, opposing motion to classify defendant's motion. You think they'd figure out a shorter name for these things by now? Filed January 9th, the media represents that the court may act on its motion without waiting for a response under Rule 711G. The court is unconvinced that a motion to classify is a motion that can be acted on without waiting for a response. And while the media has standing to oppose motions to classify a record, it's not clear to the court that the media has standing to file motions in this case. Okay. A court may consider any relevant factor, interest, or policy, both in favor and opposed to closure, in determining whether to classify or close all or part of a court record. In making its determination, a court must make findings and conclusions about specific court records, identify and balance the interests favoring open and closing the record, and if the record is ordered closed, determine that there are no reasonable alternatives to closure sufficient to protect the interest favoring closure. With this legal framework in mind, the court now turns to the pending motions to classify. Defendant's motion to classify as private, motion filed January 9th with exhibits. Defendant seeks to classify a motion he filed January 9th as private because it addresses evidence that has not yet been found and to be admissible and is of a nature that could easily taint potential jurors. If the court denies his motion to classify, defendant requests an opportunity to file a public version of the motion that redacts the attached exhibits and details from the exhibit discussed in the motion. Here's the thing. Defendant does not provide any specificity explaining why the potential evidence discussed in the underlying motion is of such nature that its disclosure could taint the jury pool. The potential evidence discussed is technical and discusses the process of scientific and forensic testing of physical evidence. It does not contain any obvious private or inflammatory information. And while the evidence has not been admitted at trial, there's no pending motion to exclude it. I feel like they're just filing motion. It's almost like yesterday, where that dude filed all of his stuff. If you didn't follow us yesterday, we talked about updates to the woman who sued the Blue Angels for the acoustic torture of her cat. And yes, you heard that right. A woman is suing the Blue Angels for the acoustic torture of her cat. If it sounds ridiculous, it is. It is. Yeah, I'm thinking about a members only on Monday. Hey, my pretty, how are you? Members only on Monday. Somebody just messaged me to remind me, okay? If you're going to file this motion to classify because this evidence hasn't been included yet, you then file a motion to exclude the evidence. It's the logic isn't logicking. It makes sense on its face. Okay, you want this out, but when you hear the judge talk about it and you logic it out, the math doesn't math. Even lawyer math doesn't math. And that's pretty bad. Yes, God, please, no cat jokes. We had all the cat jokes yesterday that we could take for a long time. In balance, defendant has not provided a sufficient basis for the court to find that the interests favoring closure outweigh the interests favoring an open proceeding and the presumptive right to access. Moreover, as the Utah Supreme Court recognized, even in highly publicized cases, a defendant's right to a fair trial can be protected through the regular, time-honored process for selecting jurors. Voir dire. Like enlarging the veneer of potential jurors, utilizing a detailed juror questionnaire, and conducting thorough voir dire of potential jurors. What a freaking concept. And asking the right questions, which means, Kathy Nestor, this is where you failed being a good lawyer. Kathy Nestor, we saw you already do a publicly televised trial with Corey Richens. It did not go well. It did not go well. In Soviet Russia, cat jokes you. Let's not mention Russia and cats because the U.S. paid, just in case you're unaware of what the U.S. taxpayer dollars have gone for in the past decade, we paid for a Russian study to cut the brainstem of cats and have them walk on treadmills. I shit you not. That is what American taxpayer dollars are going for. Russian cat treadmill studies. What they were looking for, I haven't the slightest freaking idea. Sounds like more of a torture. And where's PETA when you need them? I feel like a skid mark in the Yeah, Nestor is horrid. Nestor is like Elaine, just with more makeup. And more hair. I talked about that on my YouTube channel when I first started my YouTube channel, and I used to do that like Government Thursdays, and we used to do, where's your money going? The government spend what? Gone fishing with your tax dollars. Yeah. Defendant's request to classify the motion filed January 9th is denied. Motion to classify and motion to exclude. Defendant seeks to classify his motion to exclude cameras from the courtroom because the motion compiles a litany of unfair, prejudicial, and oftentimes inaccurate electronic media interviews, comments, and photographs. Oh yes, like all the people that are happy and celebrating that Charlie Kirk passed away are fair to him and his family. You know, we said no more cat jokes. Next person to say a cat joke is getting timed out. Gail, that one's on you. Gail has my full permission to time out anybody talking cat today. Unless excuse my language, but unless the pussy we're talking about is Bruce. All right. Defendant's motion at 2. Furthermore, the motion references court filings that are classified as private and references the publication of private information and individuals involved in this case, allegedly in violation of law. Defendant does not provide any citations to the underlying motion to aid the court in identifying potentially private information. The court is sensitive to the amount of pretrial publicity generated by this case, including an extensive amount of public commentary, inaccurate or conspiratorial descriptions of alleged evidence supporting or negating defendant's guilt. A substantial amount of this pretrial publicity is organized and memorialized into defendant's motion. Because the references to pretrial publicity are by their very nature already contained in the public arena, interest favoring closure are greatly diminished. The public already has access to the majority of the information contained in the motion. I love this judge because he's very common sense. Very common sense. Cat, the loophole, I have a wrench. we can always take that away for 24 hours. Done it before. All right. Upon balancing the interests at play, court determines that defendant has not shown that the interest favoring closure outweigh. Motion is denied or granted in part and denied in part. Court will reclassify docket 305 as public. If redacted, court will maintain the private classification on 305. Defendant's motion to classify reply. Defendant seeks to classify. They want all of their documents private. I saw yours, Bruce Catskins. That was a good one. I saw yours. Yeah. Oh yeah, we can do whole streams on that, and I will get back to that eventually. Because that was a huge thing when I first started my channel. Just basically saying how much our government sucked. YouTube didn't really like me for it, but you know what? I don't fucking care. Defendant argues his reply memorandum should be private because it references portions of the motion to exclude cameras, which is also moved to classify. Defendant does not cite to any part of the reply memorandum that references potentially prejudicial information. No, they just want them all classified because in general, not all of them, in general, they are poorly written. In general, they are whiny. In general, no one likes Tyler Robinson. Your client is not likable, and Kathy Nestor, neither are you. They are embarrassed to be called out on their bad behavior. They don't like people like me reading their motions and saying what I think of them. Because in general, I don't like them. Kathy Nestor was not a fan of people watching the Corey Richards trial and telling her how much of a horrible lawyer she was. Yeah, you had a horrible client. We're not that notwithstanding, but you are a horrible lawyer. Some of the questions that you asked were like, I wouldn't ask that if I was being paid an extra $1 million for that one question. So let's furries on Discord like Tyler Robinson. Yes, that's true. The furries like Tyler Robinson. So defendant's motion is respectfully denied. So that is that. There's more about, they have a notice of expert, Dr. Ruva. So this is the one that, and then they have 327 was the defendant's motion to continue preliminary hearing. We're going to get into that one. But then 330, they had another motion, the redacted motion to exclude cameras. And that was the last thing that it has been filed in this case. But we are going to get to that preliminary motion to continue the preliminary hearing, because this is the one where we will fact check the media. Let's put it that way. And I have it somewhere. We're just going to download it again. It is 69 pages, so we will not be reading everything word for word. We will do our best, but it's 69 pages. 69 pages. Let's think about that. How long it takes some people to get through a 20-page document, let alone 69 pages. So defendant Tyler James Robinson's motion to vacate or continue preliminary hearing pending discovery and to permit constitutionally adequate and reasonable time for preparation and memorandum in support. So I just have to, when I was reading through this, I just have, there's questions. So I'm bringing up my notepad, and I'm going to bring it up on this other computer because it's kind of nice having a laptop that's not a decade old. My laptop was so old that it wasn't able to be updated anymore, and it was just, I couldn't do anything on it. So we have to speed squid up. We're not reading all 69 pages. We are not. It is not going to happen. We are not doing it. But I did take notes because I was in the kitchen this morning doing this when I was eating my lunch. I was eating and typing because handwritten notes would have been too difficult. So I have a Word document or the Pages version. So the Pages version. Try putting Linux Mint on an old laptop. Oh, thanks. I'll pass. All right. Defendant Tyler James moves to vacate the May 2026 preliminary hearing dates, which was set for May 22nd. Pending completion of relevant aspects of the state's discovery obligations and to permit Mr. Robinson constitutionally adequate, reasonable time for preparation. This motion is grounded in a myriad of legal authority, namely the 6th and 8th Amendments, Article 1, Section 12 and 13 of the Utah Constitution, Utah Rule of Criminal Procedure 7B, 69 pages, 420 words at a time. Nice. Yes. And then there's attached declarations and exhibits. So, and yes, thank you for the $2 super chat. I appreciate you very, very much. Hey, hey, Jen Thunder, how are you? All right. Mr. Robinson seeks to continue preliminary hearing for May 2026 to a setting that allows him and his counsel to receive discovery necessary for preliminary hearing prep. Mr. Robinson has the right of preliminary hearing to present evidence, to call his own witnesses, and to have a meaningful opportunity to cross-examine state's witnesses. The following memorandum demonstrates why there is good cause for this court to continue preliminary hearing dates. First, Mr. Robinson summarizes the discovery received thus far and the diligent efforts being made to process the discovery by the defense. Next, Mr. Robinson engages with the 5-factor analysis described in Layton City versus Longcrier to demonstrate how each factor weighs in favoring of granting a continuance. Roy, you're just as bad as Onghang Hero. Just as bad. Roy, thanks for the $1.99 super chat. 69 pages might get her rise out of Mr. Hack. Yes. Thank you, Roy, for your super chat and making me blush. I didn't need to put so for those of you who are new to my channel or do not know what that is referring to, there was a case that I was covering that is in the same district, the Northern District of Florida, as another notable case. And one of the defendants was named Hugh, or is named Hugh Hathcock. And they make fun of the way I say it. And I am no longer saying it unless it's in a super chat because I don't want to say it. I am not covering that case anymore because there was a motion to seal the case and it was granted. So there's no documents, there's no updates, there's no reason to cover it on my channel. But it was an NIL lawsuit in Florida. So, yes. And Roy and Onghang Hero are the two people that will not let the way I said it go. Ever. Ever. All right. Mr. Robinson defense teams and the Utah County Attorney's Office have been diligent in requesting and processing the voluminous discovery, yet additional materials necessary are for defense preparation for the preliminary hearing. Hero, thanks for the $2 super chat. 69, oh my. Oh, your poor wife. Yeah. Yeah, and it's not a grift. It's more of a, I don't want to say it. So it has a, I'm not going to say it unless it's in the super chat, but then they super chat me anyway. And I just, like, all right. So the preliminary hearing is at the end of the day, a probable cause. So in order for them to actually have a good preliminary hearing and be able to present a preliminary hearing like they should, they need to be able to effectively cross-examine witnesses. And if you, and present your own, and if you haven't gone through all the evidence yet, your experts haven't gone through all the evidence yet, you cannot effectively put on experts. It's just it's me. Does Georgia have cancer? Oh my goodness. Oh, y'all crack me up. All right. On March 12th, counsel for the parties met and conferred regarding discovery issues and evidence the state intends to present at the hearing. Based on the state's representations at this meeting, the state intends to present discrete buckets of evidence through identified law enforcement witnesses. This includes conclusory, forensic DNA, and ballistics reports authored by the FBI and ATF, phone and social media data, testimony by law enforcement officials about the crime scene and search locations, and testimony by Mr. Robinson's parents and roommate. The state intends to offer a significant amount of hearsay identified in Utah Rule of Evidence 1102 for use at preliminary hearing, namely scientific, laboratory, or forensic reports and records, pursuant to 1102b4. Presumably, the statements of non-testifying peace officers to the testifying peace officers pursuant to that other rule, as yet identified or currently unavailable lay witnesses' statements. The state may also present 1 to 3 lay witnesses. Oh my goodness. Roy, thanks for the $4.99 super chat. It was half-cock seals. Old cat tortured by the Blue Angels. And okay. No, he is a millionaire who runs an NIL collective in Florida. But you know that. If I weren't lazy, I'd make a compilation video of all the times you've said Hath. It's H-A-T-H. Spell it right at least. Hath. Y'all crack me up and are just crazy. All right. Discovery in this case is incomplete, voluminous, and processing of it is complex. Materials from the numerous local, state, and federal agencies identified thus far as involved in this case are filtered through the Utah Bureau of Investigation. They send the materials to the Utah County Attorney's Office, where they're reviewed, Bates numbers, and redacted prior to being produced to the defense. Due to how the materials are provided to the Attorney's Office, the defense paralegal must devote a significant amount of time to their processing, error checking, and organizing before it can be reviewed and otherwise utilized by counsel. Yeah, I know. It makes for an interesting day. I love you guys, but it makes for an interesting day. In total, defense has received approximately 20,000 files, excluding digital electronic discovery provided on a hard drive during the March 12th meeting. Of these, the document and image files contain approximately 61,500 pages. Audio files are 31 hours, 5,000 video files, 700 hours of video. Digital electronic discovery received on March 12th amounts to approximately 12 terabytes. Of data and over 600,000 files. The initial review of the digital electronic discovery is anticipated to take 60 days to complete, after which time it can be determined if the downloads are complete or if additional time is necessary to obtain complete downloads. I mean, as much as I do not like the defense attorneys, because I think they're shit attorneys, they have points here. This is a lot of stuff to go through. And if they don't have it all, they haven't been able to go through it effectively, and their experts haven't been able to go through it, you can't present a good case at an evidentiary hearing. If you haven't looked at all the evidence, I'm reading fast because there's a couple of points in this that I really, really want to get to, mainly the things that the news media is talking about and the conspiracy theorists are running with. It's not the transfer, it's the going through. It's reading all those documents. Not only reading them, but actually comprehending what they say. It's watching all the videos. It's not the transfer. It's not getting all the information. It's processing it, reading through. Hi, baby. Oh. Ooh. That was a big burp. All right. Hey, beautiful. 12 terabytes. It would, a Thunderbolt would be faster, but it would probably still take hours to just transfer that. I had to transfer not that much information, and it still took me 2 or 3 hours to transfer all my stuff. Yeah. Like, keep the super stickers and super chat coming. She reads faster. Ah, nice. All right. The defense team has devoted and will continue to devote significant resources. However, the defense team is realistic, and the comprehensive review required to determine what is missing will take hundreds of hours. Angel, no. What is known at present is that Mr. Robinson has not received the forensic case files and data necessary to investigate through the use of qualified experts, scientific reports.
Mommy,
Hi.
I
Oh, hold on. My face does not unlock this phone, but that does. Can I have some?
No,
Don't use too much. Have Daddy help you.
no, no.
In his initial request for discovery, filed September 30th, 2025, Mr. Robinson requested the materials specific to forensic testing. During the hearing held January 16th, counsel for the parties discussed the status of the laboratory files, and the Utah County Attorney's Office informed the defense that they were awaiting the files. This is memorialized in a letter from defense counsel to the state February 3rd, 2026. Sorry, cough. Oh. Wherein Mr. Robinson's counsel sought specific information regarding the forensic downloads of seized electronic devices. During the meet and confer March 12th, my face doesn't unlock this phone, but it sure broke it. Ha ha, you're fucking hilarious. It didn't break it. But thank you for the $5 super chat. And hey, Dan Davis, how are you? All this lawyer speak could make one, dare I say, catatonic. Ha ha ha, you're funny. Ha ha ha. All right. So, Utah County Attorney's Office indicated the ATF intended to provide their case files to the State Bureau of Investigation as following week, but offered the caveat that it did not mean SBI would immediately provide it to the Utah County Attorney's Office. Both Utah law and constitutional principles establish that there is good cause to continue the preliminary hearing. Utah Rule 40B may grant a continuous based on showing of good cause. In any aspect of criminal proceedings, there is no other applicable statute or rule so long as it does not conflict with any statutory or constitutional requirements. As recently as 2021, Utah Supreme Court reiterated that district court abuses its discretion in denial of a motion for continuous when a party has made timely objections, given necessary notice, and made reasonable effort to have the date changed for a good cause. Usually, I don't like this the defense, but I think they have a point here. I really do. Layton City versus Longcrier, Utah Court of Appeals identified multi-factor test for assessing whether denial of a motion to continue is an abuse of discretion that informed the issue here. The factors are whether the continuance have been requested and granted, the balance of convenience or inconvenience to the litigants, witnesses, counsel, and court, whether the requested delay is for legitimate reasons, or whether it's dilatory, purposeful, or contrived, whether the defendant contributed to the circumstances which gives rise to the request, and whether denying the continuance will result in identifiable prejudice to defendant's case, and if so, whether this prejudice is of material or substantial nature. Hey, Ronnie. All right. There has not been a prior request to continue. Ms. Nestor advised the court in December of 2025 that it was likely premature to set a preliminary hearing, even one set for 6 months later, and her warning was precedent, notwithstanding Utah County Attorney's Office apparent best efforts. 2 federal law enforcement agencies, ATF and FBI, State Bureau of Investigation, have not been able to produce discovery in time for the May 2026 hearing to occur. Balancing convenience and inconvenience. Testifying witnesses identified at the state are a very small number of locally employed law enforcement officers with Utah Valley University and SBI. State identified potential lay witnesses who may testify but not confirmed. While the state intends to make very liberal use of its authority to present evidence, sworn statements obtained in compliance with Rule 1102, it has not yet identified all of the lay witnesses. Moreover, given this court's statement in December that the state was not set in stone, as it was being set tentatively, there's no reason for the state to have promised any witnesses that only dates on which they need to be available were the week of May 18th to 22nd. This motion to continue comes well in advance of the scheduled date, as did Mr. Robinson's notice in open court on March 13th of his intention to so move any logistical inconvenience to witnesses arising from a change in scheduling would be de minimis. Sometimes I really hate when they do Latin, when they could just have said it could be minimal. But, you know, they got to be smartest fucking person in the room. Just... All right. There is likely no inconvenience to counsel for either of the 2 parties to this action. The state is represented by 6 capable, experienced prosecutors. Mr. Robinson's counsel are available to conduct a preliminary hearing once the relevant evidence has been produced by the state, and the defense expert and its experts have had meaningful and reasonable opportunity to review it. The court has expressed concern about its own calendar. Defense counsel acknowledged this concern at its most recent hearing, suggested that the court may wish to set aside future dates now rather than search for them later. It may have already done so. Request for continuance is legitimate, not contrived. Where Mr. Robinson has not received adequate discovery relative to known preliminary examination evidence, proceeding without adequate discovery will result in the denial of Mr. Robinson's right to effective assistance of counsel. I think he has issues with effective assistance of counsel anyway, but that is my own separate issue with Kathy Nestor, because Kathy Nestor is Kathy Nestor. So third factor. First, Mr. Robinson has yet to receive the appropriate discovery described in the Utah Constitution. The complete forensic files and data necessary for defense experts to review the evidence and consult with defense counsel. Second, Robinson will be denied his constitutional rights to effective assistance of counsel in preparing for and at the preliminary hearing if defense counsel is unable to investigate the evidence upon which the state intends to rely. I mean, they've got a point. Preliminary hearing is a fundamental procedural right guaranteed by Article 1, Section 13 of the Utah Constitution to a defendant charged with a felony or Class A misdemeanor. The preliminary hearing is supposed to provide a meaningful opportunity for magistrates to ferret out groundless and improvident prosecutions. So, basically, you need everything prior to this preliminary hearing for discovery. And if you haven't gotten it, Nestor's about as sharp as a bowling ball. Yeah. Here, there are materials known to the police prosecution team that have not been provided. While it's anticipated that discovery in this case will be ongoing throughout the duration, the defense is seeking the materials known to be reasonably available to the prosecution. That is, materials known to be in the possession of law enforcement partners identified by the state. Both the Attorney's Office and Robinson continue to await a vast amount of information relevant to a review of the FBI and ATF's DNA analysis, including but not limited to validation studies and crucial electronic data files, the report and case files for comparative bullet analysis, lead analysis that is still in progress at the FBI. So remember that. That's one of the things to remember. bullet lead analysis that is still in progress at the FBI. The comparative bullet analysis that is still in progress at the FBI. Remember those two things? And remember also that they were stated by the defense. In addition, as outlined in the letter, there are various other forensic science discovery that are not yet complete and that must be completed so defense counsel may decide whether to proffer any exculpatory evidence relating to these areas of forensic evidence. Totally understandable. So they just continue to talk about how the preliminary hearing is a crucial stage. We are well aware that the preliminary hearing is a crucial stage. The mods are cataloging all the names of those breaking the cataloging joke rules. With respect to the guilt-innocence phase, defense counsel must independently investigate circumstances of the crime and all evidence, whether testimonial, forensic, or otherwise, purporting to inculpate the client. To assume accuracy of whatever information the client may initially offer, the prosecutor may choose or be compelled to disclose, is rendered ineffective assistance of counsel. Oh boy. In addition to investigating the alleged offense, counsel may also thoroughly investigate all events surrounding the arrest, particularly if the prosecution intends to introduce evidence obtained pursuant to alleged waivers by the defendant. As the U.S. Supreme Court has stated, a myopic instance upon expeditiousness in the face of justifiable request for delay can render the right to defend with counsel empty formality. And they mentioned the Sixth Amendment. Basically, all of this is the same stuff over and over again. She's just messing with different case law. The receipt of discovery is not enough. The defense must be permitted sufficient time to consult with necessary experts to determine what evidence the defense intends to challenge and present. It's fair. As indicated above under ABA guidelines, the defense lawyer's obligation includes subjecting all forensic evidence to rigorous independent scrutiny. To discharge this obligation, defense counsel must necessarily rely on skilled experts in each of the areas of forensic evidence being offered by the state. The defense must both subject the prosecution's evidence to searching scrutiny and build an affirmative case of its own. Yet investigating a homicide is uniquely complex and often involves evidence of many different types. Analyzing and interpreting such evidence is impossible without consulting experts, whether pathologists, serologists, microanalysts, analysts, DNA analysts, ballistic specialists, translators, or others. Neither defense counsel nor their experts can discharge their obligations without full and complete discovery of all information underlying any forensic analysis. So, with the assistance of appropriate experts, counsel should then aggressively re-examine all of the government's forensic evidence and conduct appropriate analysis of all other forensic evidence. Defense counsel in this case have begun the multi-step process of requesting and reviewing forensic discovery, locating and retaining appropriate experts, providing the experts with all necessary materials, performing the aggressive expert re-examination mandated by the guidelines, and consulting with experts after the re-examination has been completed. But this process is far from complete and in some instances has just begun. For instance, at the March 12th meeting, the state indicated that it intended to introduce the autopsy report into evidence without any supporting expert testimony. The autopsy report, completed September 16th, was not produced to the defense until November 13th. The photographs taken September 10th were not produced to the defense until March 18th of 2026. With the report and photographs, the defense is now in a position to provide an independent pathologist with some of the discovery tools necessary to conduct an independent evaluation of the autopsy. But it is anticipated in the course of that evaluation, the expert will identify additional information that must be requested from the state. For example, competent forensic pathologists typically request that tissue samples be prepared and examined as a part of a thorough forensic autopsy. I don't necessarily disagree with this. And I just don't understand why pictures that were taken on September 10th when the autopsy report was produced November 13th, why didn't you produce the pictures too? That to me is the state being shady. Totally, totally to me being the state being shady. And Sir Frank Otter, thanks for being a member for 16 months. So good to see you. I've missed you. I haven't seen you in a while. So what I'm hearing is the state is fumbling. I wouldn't necessarily say fumbling in my opinion, but like I said, not a lawyer, layperson, but if the the report was produced November 13th, why would you not produce the entire thing, including the pictures? Why did you not produce the pictures that were taken in the autopsy until March 18th of 2026? 4 months later. To me, that screams like they were hiding something or trying to delay, which is weird to me because the state of all people shouldn't be the ones to delay. Like, something just not, something is just, yeah. They have my permission. They have my permission. I said the next person who makes a cat joke, my mods can fully time people out. And people wanted to push my mods' buttons. And the one thing you don't do here, remember my mods bite. Do I need to play the petty chat rules? My mods bite. Oh, but hey Jeff, how are you? I've also been on replay crew and my state has been on fire. Oh my god. I didn't realize your state was on fire. I have not been keeping up. I've barely been keeping up with my own stuff, let alone the rest of the world. I've the next one and the next one and the next one and the next one. Yeah. This is one of those things of like, this is why things need to be public. Because right here is holding the state accountable. Yes, I hate the defense, but at the same time, I hate the state. And why is the state being ridiculously stupid in the sense of why did you produce one thing in November, but you didn't produce the photographs that went along with it? You would think it would be in one file, one digital file, one folder, all of it together. Yeah, why delay? That makes no sense. Seemed like an open and closed case. Other than that, how did he get on the roof and not be noticed? At the same time, we don't know that he wasn't noticed. We just don't know if the people who did notice said anything or the people that they said something to cared. Because remember, somebody got on the roof and shot at the president, and people saw him and nobody did anything about it. So people could have seen him and just kept their mouth shut. Who knows? There's really no way of knowing without each individual person's statements. That's what's hard to know. And that's where it's one of those things of like, when we do talk about stuff like that, we talk about it in the mindset of, I know it's conjecture, and we discuss it in the mindset that we're presenting it as, but what about this? But what about that? But what about this? I don't present any of that stuff as fact because I don't know it. They could have reports that we don't know about, because just like any other trial, yes, Charlie was famous, but at the end of the day, this is just a state case. This is no different than Sarah Boone. This is no different than Carly Gregg. Speaking of Carly Gregg, she does have oral arguments with the Mississippi Supreme Court May 27th, and we will be viewing that. I already have it down in the calendar. If you don't know who Carly Gregg is, I have a whole playlist on her. So we, it's just, the state needs to be on top of everything. But we're also not going to know things until trial, because that's not how the court system works. And people are like, well, Charlie's famous, we should be able to see everything. It's not how the court system works. Just like I'm telling the defense that, sorry, you can't get everything sealed just because you're You can't get cameras out of the courtroom just because you don't want your person on trial, or you don't want your person on camera and you think it's going to be prejudicial. Well, welcome to 2026 and transparency in the court system. If you don't like it, stop being a defense attorney. I don't know what to tell you. Like, as indicated in the March 25th informal discovery request by the defense, even more substantial discovery issues exist with respect to the DNA and ballistics reports that the state has indicated it intends to offer at the preliminary hearing without any supporting expert testimony. See Novak Declaration Exhibit F. Here's the thing. So can we turn this down? Thank you. What's the matter? You want up, you want down. You want up, you want down. I don't know what you want. Bye. I love you. Can you close the door? No? Okay. The summary DNA reports produced by the state, or to the state by the FBI, indicate that both agencies recovered minute quantities of DNA on various items of evidence, which the report opined consist of mixtures of up to 5 or more individuals. Both agencies employed at a commercial software product called STR Mix in an attempt to sort out the various contributors to the DNA sample. Courts have excluded XTR Mix and similar genotyping software analysis when appropriate validation and use of the reliable procedures have not been demonstrated. Ugh. Remanding the case for a Daubert hearing because it's not clear whether the STR mix had been properly validated for use with 3- and 4-person mixtures containing a minuscule amounts of DNA at issue here. So, granting the motion to exclude DNA evidence analyzed by STR mix due to concerns over number of assumed contributors and the lab's lack of validation for a higher number of contributors. This was a problem in the Georgia cold case with validating DNA. Nope. All right. All the STR mix analysis is unreliable because the government has failed to demonstrate that it has a laboratory internally validated the available feature of its probabilistic genotyping software that is applicable to cases where, as here, the defense contends that biological relatives of the person tested are potential donors of the DNA, and the government has not demonstrated the reliability of the laboratory's methods for determining the number of contributors and complex DNA mixtures in cases like this one, in which the potential for DNA allele sharing with biological relatives is high, in which the analyst was not provided with key information needed to make that determination. So, oh no. As these cases indicate, determining the number of contributors to a DNA mixture and determining whether the FBI and ATF reliably applied, validated, and correct scientific procedures in conducting its STR DNA analysis and its STR mix interpretations is a complicated process, which requires the assistance of various types of experts, including forensic biologists, geneticists, system engineers, and statisticians, all of whom must review and evaluate the several categories of discovery requested in the defense's initial discovery request. And in its March 25th informal discovery request, as that request documents, there are several areas of critical DNA discovery that have yet to be provided, including but not limited to validation studies and electronic data files from both agencies. So it's not that things haven't been tested or DNA rules him out as it's been reported. However, it is that DNA is not disclosed. It's that the defense hasn't been able to verify anything. So it has been misconstrued in the media. The headlines are continuously arguing that this is what the evidence proves. And it's not the case. The case is we don't know what the evidence proves or disproves because we don't have all the evidence, and our experts have not had time to go through all the evidence. This is where the media and people who don't actually read the documents but take a headline and run with it for clicks and the views and think they have, and people believe them because they have clout and millions of followers. YouTube world, you know who I'm talking about. I'm not going to say certain people's names, but y'all know who we're referring to, who has been the loudest voices in the Charlie Kirk conspiracy world. We don't do conspiracies here. We do facts. And in order to get the facts, we have to wait for the trial. That is just the way shit is going to work. Yes, it's intentional misinformation because they're all making money. And when they tell you, oh, this person's making money or this person did it because they're doing, they don't have all the facts unless they've sat down with the cops and they've looked at all of this and then they've been able to compare it to prior case law and prior DNA evidence and say, well, this isn't valid, which only the court or the experts in the court system are going to do. They don't effing know. The fact is when they say it, they are giving you their personal opinion warped by the fact that you think they're telling the truth based on a couple headlines. Based on, I saw a headline that the document said this. No, this is why we read through the documents, because headlines. Let's look through what the actual headlines say. If I just Google Charlie Kirk. So Tyler Robinson teams probes bullet match in Charlie Kirk. Charlie Kirk accused assassins lawyers question link. These are just what was the Daily Mail headline? That was the one that started all this. This is what the Daily Mail reported. So we're going to stop sharing this for a second, and we're going to look at this was the Daily Mail's. This was the Daily Mail's. This is what they reported. Bullet used to unalive Charlie Kirk did not match rifle allegedly used by suspect Tyler Robinson, new court filing claims. Say what? Say what? So going back to the actual document, because, the document is the only thing that matters. So the defense goes on to claim that they retained biologist Dr. Libby Johnson. There are two federal agencies DNA testing in this evidence. So we got through the DNA. And here we talk about the we will talk about the bullet. So what is preventing that plan from going forward is the incomplete status of the DNA discovery. The defense literally said the DNA is incomplete. We can't effectively analyze it to see if it rules him out or if it includes him because we don't have it. They did not say, as you might see in a headline, the DNA doesn't match. They did not. That we're going to get to that because that headline, we're gonna see what the defense actually said in their argument. And I hate this defense team, so take this with a grain of salt when we are reading through what the defense actually said about the ballistics. Regarding the firearm evidence, the defense has been provided with an ATF summary, which reports indicate the ATF was unable to identify the bullet recovered at autopsy to the rifle allegedly tied. That's all they said, unable to identify the bullet recovered at autopsy to the rifle. They have not, that's all that was said that led to did not match. So think about that. So all right. No problem. Although the state has not indicated an intent to produce this report at the preliminary hearing, the defense may very well decide to offer testimony of the ATF firearm analysis as exculpatory evidence. In order to make this determination, it is necessary for the defense and its firearm expert to review the ATF case file and protocols relating to this exam, which have not yet been provided. So they don't even have the full report. They even tell you they don't have the full report. Yes, right here. That's the only part that has been completed. And I was looking at I have to download this to my, here we go. I was looking at a document, which we will get into in a little bit. It's the state has also indicated that the FBI is in the process of conducting a second comparative bullet analysis as well as bullet lead analysis, but these are not yet complete. Again, until the defense receives the case files and protocols relating to these analyses and has them independently evaluated by its expert, they will not be in a position to assess the reliability of this evidence if either the state or the defense decides to proffer it. That right there led to the headline from the Daily Mail. Bullet used to kill Charlie Kirk did not match rifle used by suspect Tyler Robinson, a bombshell new court filing states. Daily Mail lied through their damn teeth. Either that or their reading comprehension, Brits. I know y'all don't speak the same version of English as us over here in Americanese. But is your reading comprehension, I'll have to ask Spawn Trooper, is the British reading comprehension really that poor? So where is Spawn Trooper when you need him? Oh, he isn't here? Spawn Trooper. Just the man I wanted to talk to. just the man I wanted to talk to. So this document right here says until the defense, it says the ATF was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. Okay. Then it says the state has also indicated the FBI is in the process of conducting a second comparative bullet analysis as well as the bullet lead analysis, but these analyses are not yet complete. Again, until the defense receives the case files and protocols relating to these analyses and has them independently evaluated by its expert, they will not be in a position to assess the reliability of this evidence if either the state or the defense decides to proffer it. Does that measure up or make sense to this headline? Bullet used to kill Charlie Kirk did not match rifle allegedly used by suspect, new court filing claims. That was the court filing that they were referring to. I don't know. I know we speak Americanese over here. and we don't speak the English version of English. But is there something that's been lost in translation? That sounds like someone was having a stroke while being electrocuted with a cattle prod. Okay. Hold on. Ugh. Whoop. I'm just saying we got like a lost in translation here. Cause oh boy. Yeah, I'm just, but by who? Because it didn't affect the defendant. Hello. You there?
Sorry, I couldn't stop laughing.
Like,
That sounded like, seriously, just put that one back up. Put that sentence back up. First of all,
which sentence? The headline?
the headlines and then the part in the script, because even the
I really
person,
wish I could.
either the person. Excuse me a second.
So that is the headline. All you've read, Ronnie, is the headlines.
Oh,
yeah. And this is why we do what I do here, and this is why, like, I read what I read here, because the this, and people believe this, and this is not the only one. This was just the first one that I know was talked about by the Charlie Kirk show, that made headlines in, when headlines make headlines and people make YouTube videos about weird headlines.
whew, I'm back.
You know that things are crappy. So
Okay.
yes.
Right. Okay. You sit back and enjoy the ride. Right. First of all, the Daily Mail, right, are basically a fucking. If you take toilet paper and you take cat shit, you mix them both together. That's what they eat every day. Right? They're full of crap. First of all, okay, how the hell can the round that's already be identified via ballistics that came from the weapon they found, right? And even if it didn't, okay, the bullet will be in such a bad shape. It'll be, I mean, you're looking at about 25 to 38% chance of actually fucking, how can I put it?
Yeah, we're gonna get to that. I have a whole document that I found on a simplified guide to firearms examination. So
The thing is, go back to the court document. Let me read it out. Right. Regarding the firearm evidence, okay, the defense has been provided with an 80th summary. So basically, like a fucking fact-finding report about the rifle, the round, whatever, which indicates that the ATF was unable to identify the bullet recovered at the autopsy to the rifle alleged tied to Mr. Robinson. Although the state has not indicated. Right. Now, I presume a lot of people here know what happens to a bullet round when it hits a body compared to when it hits a solid object, correct? Yeah, like a pistol round, depending on type of round you use, right? It will either blossom up like a flower petal, or what will happen, you'll get a full metal jacket, i.e., like basically fucking piece of metal, right? And what it'll do, as soon as it hits an entity, a body, okay, the round will deform. right? However, depending on what part of the body it hits, you always have a 92% chance of the round hitting a bone. All right. Now, that part there, right, about the fact that the bullet recovered at the autopsy, and then, not indicating, well, basically, how the hell can you make a statement like that when you haven't even fucking stated, yeah, the round, we tested it, we did this, we fired test rounds from the actual rifle that we found, and that's the only time they can turn around and say the ballistics of the round taken from the autopsy and the rounds that we've fire tested from the actual weapon don't correspond, because you got rifling. You're muted, by the way.
They just said they just said they were unable to make a determination. They didn't say it didn't match. They just said based on the fragments they had.
Yeah, because that means then that bone, that round, when it pardon me, I do apologize if this offends anybody or upsets anyone. When the round entered the body at the neck height, there's a possibility that it hit the collarbone or some sort of bone, defragmented to a point where they couldn't fucking reestablish the rifling at the edge of the round. Because don't forget, some rounds, like a 7.62, it could have like a brass body, but it's got like a jacket. Okay, the jacket will disintegrate on any type of impact, right? So if it hit bone, then that round will disintegrate, the bone will disintegrate, so therefore you've got less chance of actually identifying the rifling. That is like a thumbprint from every rifled weapon.
Then Alan brings up a really good point. Utah County is the second largest county by population. I think it's highly possible to find 12 people that have not heard of Tyler Robinson out of 780,000 people. Yeah, that's probably a good point.
Yeah.
And I take this, like, we're just talking about purely about the headlines, and I hate this defense team. Kathy Nestor is a horrible lawyer, in my opinion. However, I've seen one of his lawyers at another case. She was Corey Richens' lawyer. Yes, Corey Richens was a horrible client to have. However, bad lawyering job.
Yeah.
However, with that being said, the defense, in their defense, didn't even say what the headlines are taking and running with, which is one of the reasons why it's very important for people, in my opinion, to look beyond headlines and actually look at the documents. Because what those headlines are saying is not even what the defense said. The defense specifically said that it could not be identified and that the FBI has it. And the FBI is in the process of conducting comparative bullet analysis, is lead analysis, and that these are not yet complete and that they don't have it.
Yeah, let me give you a comparison. Maybe this will help. If you take the Daily Mail, the Guardian, and a couple of other newspapers from the United States or the kingdoms of the fucking the fucking cockwombles here. Okay, if you look at them, basically the Daily Mail is the equivalent of the CNN. Well, does that help? Does it help? Because the thing, they will hit the headlines. They will change the headlines to their narrative, so they get a lot of views or a lot of sales and shit. Right? The fact of the matter is, from what I've gathered just by reading this, they haven't substantiated evidence of the bullet that entered his body. They can't basically tie it to the weapon due to the state it's in. So that therefore they have to send away any of the fragments or anything they've recovered to a secondary laboratory for it to be then really looked at.
And the FBI has a lot more resources than the ATF.
Yes. Because that's the FBI, that's one of the things the FBI are good at.
Yeah, the ATF is in more enforcement. Their lab. This is why the FBI, they send everything to the FBI. Everybody sends everything to the FBI. Like, because they only have limited resources. The FBI has the best resources of any government agency.
Yeah, because here's the thing. The FBI can take part of the clothes right where the T-shirt was, where the entrance wound. They can take swabs and DNA and all that good shit, which the ATF and other laboratories can't do. The FBI have specialist fucking laboratories for this stuff, and I'm surprised they didn't send it to them in the first place.
So they go on to mention there are also several other categories of incomplete forensic discovery outlined in the defense's informal discovery request. Until the defense receives the case files and protocols relating to these analyses and has them independently evaluated, which all take time. This is not CSI or NCIS where you get DNA and ballistics overnight.
Nope.
This is weeks to months. Even if it's a high-profile case that's moved to the front of the line because you have friends in high places, it still takes weeks and months. And now you have to turn it over to the defense and have their experts retest it, reanalyze, reinterpret the data, write reports, give it to the defense team who has to read it, interpret it, ask questions, and figure out how they're going to present it.
And
all
then
of that takes time.
Yeah, and then at the same time, both sides have to get their own specialists in, their firearms specialists in, or diagnostic. Oh God, what's the word for it?
This is why the wheels of justice turn slowly.
Yeah, and like you're saying, it may take weeks or months. No, it will take months because they have to richly. I mean, I've had the pleasure of actually, being, where we went through a place like that. But the
Roy
thing
says,
is,
you mean you can't solve a case in 1 hour in a prime time slot? No.
I mean, it's just like the same thing about the guy who took a pot shot at the president before, at that place. I found it very interesting that that went very quiet, very easy. But over here, they were going, "Oh, fucking, they did this, they did that." This is the problem. If it's being tested, it's being tested. You don't make a big deal about it, like in that one page that you were reading, because it was like someone was having a freaking heart attack while being fucking kettle prodded while sitting on the front. Yeah, but if they're saying they can't get anything from it from a normal laboratory, I said, well, you got about a 40-60 chance of actually getting anything, because if it hit bone, that round would have disintegrated. People think it's like the film, you get shot and then oh yeah, next thing you know, you got this perfectly 7.62 round that was about 1 inch long, and it's about fucking 9 mil thick, and they just pull it out and it's in pristine condition. Yeah, sure.
Yeah. It's in pristine condition. It's in one piece. It's still silver. There's no human tissue on it. Because remember, those fragments have human tissue on it.
Yep.
You got to get the human tissue off of it too, which requires DNA experts, and you have to get people who are good at getting the stuff off of. Because if you do have rifling if you do have rifling patterns still on the bullet fragments, there's a good chance that you have DNA in those rifling patterns. Yep. And if you remove that DNA evidence wrong, you can screw up the rifling patterns, which screws up the bullet analysis.
I mean, I could say how
I'm not an expert, but I've shot enough pew-pews to know the difference. You can, if you've cleaned a weapon, you can see the rifling.
I mean, I could tell you how to remove DNA from any surface, but that's illegal. But here, the thing that gets, excuse me for a sorry cough. The thing that gets me is that like the problem is cases like this. Yes, it was public. Yes, it was a very, very sad thing to happen. right? However, this shouldn't be done publicly. It shouldn't be done publicly because the thing is, you're gonna have every single freaking pushchair freaking judge sitting there going, "Oh no, when the bullet entered at an angle of 16.2 fucking degrees, it no." You know, can you prove that there was an exit wound? No, there was an entry wound. But you know, did it rifle? Did it tumble? You know, did when the round entered the body, did it tumble or did it? You know, did it go? What's that?
So let's turn on my.
You've been specific, scientific.
It's a barrel.
Oh right, okay. I was like, what the hell are you? Why are you putting your lipstick up? Okay, right, okay. That's a 45.
Yes, this is my tank tip.
Yeah.
This is my.
Yeah. Don't. Yep.
It's taken apart. It's all disassembled.
Yeah. So that's a 45.
You can see the little lines in there.
Rifling.
That's the rifling patterns.
Have you got a little light, and then sort of side like?
All I have is my cell phone.
Yeah. Actual fact, let me do something for you. Hang on a minute. Here you go. 1 second, please.
It's my side chick.
Oh wait. Oh no. Wait. Right. Okay.
Yeah, it's just a tube. It's just a metal tube.
1 second. You're gonna like this.
It's only 4 pieces. It's really easy.
Right. Do me a favor. Check your private. I mean, fucking. Let me rephrase that. Check your DM, please.
Thank you.
Hang on a minute. I'll do something better than that. Please hold.
I'm going to go do something and help someone. So I am going to bring this image up, and then I will be, I will let you discuss it, and I will be right back.
Yeah. Okay. Okay. Right. Where am I? What am I doing? Oh no. Right. Okay. If you all can see, if you can all see the pictures, right? Now the thing is, when you look at this picture, now you need to remember this is a circle, right? It's a circle. So the round, when it fires off, will be turning in the rifle. Yeah, that's why it's called rifling. The rifling helps it to basically it helps it to keep a steady line of fire. So basically, when you fire it, if it was like non-rifled, right, there's a possibility that it's not as accurate. Now, rifling makes it very accurate, and I'm just trying to find another one, right? Because you got basically it's like the top one is a standard rifling, right? So as you can tell, it's got more lines in it. The bottom one. Now that there is a fucking. I can't remember that one. I think that's for. Hang on a minute. I think that's for fucking. 1 second, please. I think it's a 5 groove ratchet 8 groove octagon. Standard rifling was square and create sharp corners where you contacted the bullet. Barrel manufacturers then create different rifling patterns to help keep the bullet as smooth as possible. However, it's a trade-off between gripping the bullet enough to create spin while distorting the surface and that's where you get the rifling on the round. All right, now I'm trying to find a picture so you guys can actually see what it looks like when a round has been fired. This also will give you an example, right? Because the thing is, there's two different. 1 second, guys. I'm just finding this for squid. Oh God, what's that? Right. So basically, what you have to understand. So if you're looking at that picture, all right, you see the little profile. Okay. The black little teeth inside the barrel are called land, right? So that's what causes the indentation on the bullet. The groove, okay, right? That is basically once the round is fired, it will basically it cuts its way down the barrel. Now, when it's cutting its way down the barrel with the pressure, the velocity of the powder, right? It makes it start to spin. Yeah, and the thing is, what you have to remember is that the round is more accurate if it's rifled, and it goes further. Now, when you've got a smoothbore barrel, right, it can cause unstable flight for the round. Yeah. Okay. Depending at what distance depends the stability. So what I'm going to do, I'm going to send Squid another picture, and this will give you an idea of what I am talking about.
So from what I understand, it is not like the TV shows where you can compare an exact bullet to an exact weapon. What you can do is find an exact or a bullet with a type of weapon, like a bullet with an AR platform or a
no, yeah. I mean, every right. Okay.
It's not going to be this specific fragment with this serial numbered weapon.
No, it depends on the rifling, because don't forget, it's just like the military when they're investigating a homicide or anything like that. I mean, I don't know if you've ever come across it or heard about it. When, say, for example, you're in operational theaters and something happens, okay, they will then check. They will then check the weapons, and what they'll do. Each rifling is unique. Each indentation on the bullet is unique to the rifling. Every rifling cannot, like, it is virtually impossible when they are actually making these pew-pews and they're creating the barrels. Every barrel is going to be different. It's going to have its own unique fingerprint. Not every barrel is going to be unless it's smoothbore. If it's smoothbore, even then there's a possibility that you can identify it from a different, it's like they identify the weapon. However, with rifling, it's like a freaking fingerprint.
Greasy.
And I've sent you another picture, by the way.
Greasy.
Well, of course it's greasy. You're supposed to but don't put too much. You need to wipe it off once in a while. Let it sweat.
Well, yeah, but I just got it all over my fingers.
No, you're supposed to, but
I know. Right. I know. I'm not complaining about it. I'm just like, it's been a while since I.
Yeah, but going back to this, right? I personally think this is going to go on for quite a while. This is going to go on for quite a while. But at the end of the day, the only people who can actually come to a conclusion is from the FBI, who are specifically trained and have the laboratories to actually do this, because there's going to be so many different fragments, and it's going to be a freaking headache.
Hop number 9 is the best perfume. Yep. But either way, it's been a while since you the tube. Sorry, I couldn't resist.
Oh,
Jeff,
wow. Look what I found. Oh, you're going to fucking hate
in
me
most
now.
cases, we can match the tooling marks caused by specific rifles' actions. Can't rely on the actual fired bullet. And that would be where, correct me if I'm wrong, Jeff, but that would be where the FBI doing a comparative analysis would come in. Just a
You're going to hate me now.
what am I gonna hate now?
Idiot's Guide to Conventional Rifling. 8 lands and grooves. Fucking try and explain that.
No, it's not.
Yeah.
I will show it just for the sake of showing it, but then we're gonna get back on topic because
and it's showing you different. There you go.
That's what I thought. Like I said, I don't claim to be a ballistics expert. I just know inconsistencies when I see them, and I also know that we don't live in the world of CSI or NCIS where you can match an exact bullet fragment with an exact gun. It just does not happen like that.
Yeah. Well, one thing all I can say is this: with that type of angle and possible bone impact and everything else, there was no exit wound. This is going to go on for a while. Even though how sad it is that what happened is very sad. However, it's going to go on for a long time. Yeah. And go on.
So we're just going to get back into it because we just had this. When you see headlines that say this said this, I don't take it with a grain of salt that I hate this defense team and I'm siding with the defense team on this one. The defense team did not say that. And the defense team's motion did not say that. And I do not like this defense team. But all those headlines that you see about bullet didn't match, DNA didn't match. Defense claims that defense didn't claim. Defense is simply saying we need more time because we haven't gotten everything.
You see, the defense will do anything to prove. How can I put it? They will try to defend. They will try to do anything to either get non-guilty or.
And I agree with that. However, in this case, in this specific instance, I agree with the defense that they don't have all the discovery, and you cannot effectively present a evidentiary hearing without the evidence. And to present an evidentiary hearing on May 22nd without the evidence, you can't effectively defend what the state may present when you don't have what the state is going to present. It's not fair. And as much as I do not like the defense, and as much as I do not like Tyler Robinson, if he does not get a fair trial, today it's him, tomorrow it's you.
Yep. Well, I mean, let's be honest with you. Fair trials lately fun. Well,
I don't know. What's her face? Letitia Staunch just got a new trial, so it's possible. So it's So
I'm just trying to find you something I'm just trying to help.
But
you carry on talking.
Right. The requirement that a Utah criminal defendant not be held in prolonged custody unless a probable cause finding is made after a preliminary hearing gives effect to a vital constitutional right. The determination of probable cause, right by the Fourth Amendment, is prerequisite to an extended restraint. Whatever procedure a state may employ, be it grand jury, adversarial hearing, or other judicial determination, whatever specific time period in which the state requires this to be done, the state must provide a fair and reliable determination of probable cause. Blah, blah, As demonstrated, the request for a continuous obtain a full and fully investigate appropriate discovery is legitimate. I mean, I don't disagree with the defense here. I don't disagree with the defense here. They just go into more case law in this footnote. Mr. Robinson did not contribute to the delay resulting in the request for a continuance. The defense is diligently processing and reviewing the voluminous discovery received in this case. Defense has also made efforts from the outset of the case to procure not only the reports from forensic testing, but the underlying materials for expert review. The defense and attorney's office have communicated verbally and in writing concerning these materials over the last several months. The delay here does not lie at the feet of the defense, nor the Utah County Attorney's Office, but with the law enforcement agencies that have delayed in providing the requested materials. Prejudice would result from proceeding with a preliminary hearing before the relevant evidence has been produced to Mr. Robinson and his counsel, have had a meaningful and reasonable opportunity to review it and consult with experts. The fifth factor, after trial and conviction, is the propriety of a trial court's denial of a continuance, looks at whether the denial resulted in identifiable prejudice. English is hard. Daily Mail, take note. While this factor is only relevant retrospectively, it suggests that denial of Mr. Robinson's motion to continue the preliminary hearing until the relevant discovery has been produced, and his defense team and their experts have had a meaningful and reasonable opportunity to review it, would be prejudicial.
I mean, Daily Mail. I mean, I'm sorry, but like the Daily Mail's like the freaking CNN. They're much used as a fart in a spacesuit.
True, but once one person does it, everybody does it.
Well, they've been doing it for a while. I mean, let's be honest. Newspapers in both of our countries are just ridiculous. You know, I mean, for them, it's about views. It's about eyes on the page. They're not in. If they get like anywhere close to the actual fact, then I mean, we'll be lucky. I sent you a picture of various different rounds after they've been fired. These are test rounds, just to give people an idea of like when they're doing ballistics, they fire the weapon into
a chamber,
either into timber, rubber, water. If they fire into water,
I said a chamber.
A chamber. There you go. Sorry,
but it doesn't. It's not the same as a human analog.
No, but they do test that. They do like. I don't want to go into it, like no. But if you that's just an example of some of the rifling on different various rounds. And I think you got a 7.62 and a what's it called?
Yeah, but we are 28 pages into 69.
No, go for it.
We're the DNA and the ballistics were just a small part of this, but they were the part that the media has taken and ran with, and I wanted to make sure that we spent a little bit of time specifically pointing out what the headlines were saying versus what the actual motion was saying before we moved on to the rest of the motion. So Spawn, Jeff says I can send you links if you want to FBI's NIJ firearms forensic training materials if you would like.
Oh, thank you very much.
He said just ask, so you have to ask.
Oh, yeah, Jeff. Like once you get off your ass, mate, can you just send me the links to the training material? Thank you very much. Love you, darling.
If he gets off his butt, his wife's gonna kick it.
Oh, yeah, good point.
Just saying. So be careful about standing up, Jeff.
Do you know I was actually a couple of years ago, I was actually looking at doing some courses. And one of them was crime scene investigations course. But then I looked how long it would take and I was like, no, thank you.
Yeah, I know, but they're also expensive, and it's one of those situations where things cost money, and things cost money. So remember, this is the government we're talking about. So yeah. I know they waste money on stupid shit, but they don't put money towards things that actually need shit. So a continuance would have both provided defendant more time to prepare and to challenge the expert testimony and allowed him to consult with his own expert. As examined in Part 3, Mr. Robinson has a constitutional right to the receipt of appropriate discovery and have counsel effectively and competently cross-examine witnesses and present his own witnesses and exhibits. Moreover, in a capital proceeding, Eighth Amendment requires heightened standard of reliability at every stage. That is true. It's a capital case. In a capital proceeding, generally, this court has demanded that fact-finding procedures aspire to a heightened standard of reliability. Where evidence has not been yet been produced is both highly technical and scientific and is the basis for expert opinions that will be proffered only through reports deemed reliable hearsay under Utah Rule of Evidence for purposes of a preliminary hearing. I have a feeling the judge is going to be like, fine. So all 5 factors establish good cause for continuance. I think, yeah.
The thing here's the thing. I think there's a bit of tunnel vision going on here, with the utmost respect, not from you, but from both the newspapers and this document, because they're all concentrating on the ballistic evidence, the DNA, ballistic evidence, and everything else. What about powder residue? What about the weapon itself? What about DNA on the weapon? You know, like when the position
well,
where
they just say DNA. They just say DNA, and they talk about the testing for DNA. They don't exactly say what what is being tested. They don't specify. However, it's one of the situations where they, in the first pages, they mention other things. The DNA evidence and the ballistics are just things that I've seen in the headlines, people talking about, that I wanted to dispel the misinformation. We talked about other stuff in the first few pages. I just wanted to spend a significant amount of time talking about the DNA and the ballistics in comparison to what the headlines are saying about what this document said compared to what this document actually said.
I mean, like, and
it's not tunnel vision; it's intentional propaganda.
But hear me out, Jeff. Hang on a minute. Like, maybe I need to finish sentences before I carry on. Here's the thing: Daily Mail and newspapers in general will exaggerate, right, the actual fucking topic. And as you can see here, they've exaggerated it. But at the same time, my thought is this: if they're doing the DNA on, the bullet fragments or whatever, I'm surprised they don't have other parts in it, like the weapon, the rifle, the position where he fired from, his clothing. They've done DNA checks on him about for rifle powder residue and you're getting too expansive for what. Yes, I know. You're getting too expansive for what this document is for. Yeah.
So they're trying to get a continuance of an evidentiary hearing.
Yeah.
They only needed to mention there was 5 factors that they needed to meet to get a continuance according to the case law. And that was what they mentioned. They talk about other stuff and how much stuff they have. We read through all the rest of it. So before you got here, other stuff was talked about. However, that you're getting too expansive for what this document is for. This document is to make sure that they get a continuance, and they're mentioning what they need to get a continuance. And the DNA and not having the DNA testing completed by the government or the ballistic testing is the quickest way to say, hey, we don't even have this yet. The 2 things that the state is going to use, ballistics and DNA, we don't even have it all yet. The state and the government's not even done testing it yet. And you're expecting us to go through an evidentiary hearing. So it was narrowly focused because of the fact that those are the things that the state intends to put on at this evidentiary hearing, that the defense doesn't even have yet, because the government's not even done presenting it or testing it yet. So I understand where you're coming from, but like, you're too big and for what this document is trying to accomplish. So getting into all of the, because that was 28 pages of so much fun, getting into the declarations. So evidence, forensic evidence at the preliminary hearing. This is the declaration of the attorneys. Counsel for Mr. Robinson met on March 12th to discuss the contours of the preliminary hearing. Counsel for the state informed Robinson's counsel the state does not intend to call live witnesses at the preliminary hearing any of the forensic examiners who have conducted forensic examinations on collected evidence, but intends to proceed the way of Utah Evidence Code, which purports to authorize the prosecution of proffered reports of these examinations in lieu of live testimony. That's the part. They don't have those reports, and those reports are not completed yet. How can the defense cross-examine or test these reports and scrutinize these reports if they don't even have them?
Yeah. And the same goes for prosecution as well, because prosecution are going to need those documents to actually give their argument.
Yeah, and the prosecution has more of them than the defense does. So
I thought there was I thought that, like, prosecution has to what's it called? When you have to hand over anything that you have so they can fucking scrutinize it.
And Gail, just remember, just like when we talk about the Hales case and we talk about Belatho and the judge, that not being his only case and it not being the sole focus of one person or one lawyer and this is not the FBI and ATF's only case that they are working on. So things get time. You get someone who is unalived and they need something immediately, or something comes up and there's something wrong. Things take time. And then you not only have to take time to test it, now you need to interpret the results. Then you need to write a report. Then you need to give that report to the state. The state has to turn that over to the defense. Now the defense needs to go and have their experts look at it, read their entire report, do the exact same tests, in addition to doing their own tests, to scrutinize the state's tests, do their own tests to prove prove different results, or if they have different ways of doing things, then write their own report. And now you have two reports that the lawyers need to compare and then figure out how they're going to proffer it into testimony.
And don't forget the independent examiner as well.
That's the defense. That's the independent.
Yeah, that's what I meant. That's what I meant.
Yeah, that's the defense. That's what I meant when defense and the defense tested it. That's the independent. When the defense tests it, that's the independent expert.
Yeah.
So it takes. Each of these steps takes time, and as we've noticed, Kathy Nestor, that's not her only case, and I'm assuming that these are not these other lawyers' only cases. So, and remember, like these hearings were set 6 months ago, and even 6 months, they're having to move it, and this is not this judge's only case either. So, like, things take. The wheels of justice turn slowly for this specific reason.
I mean, it's like, what do you say? Another 18 months, probably?
2 years. 2 years at least.
Yeah.
2028. Yeah.
Yeah. I mean, like, I like what Stats has said is like, yeah, you'd rather be thorough and, dot every
Hey, Stats. We need courts to be the gatekeepers for people and fairness. So much going on in the world. Yeah. So importantly, most forensic examiners are employed by 2 federal law enforcement agencies, which have performed the vast majority of forensic examinations. 2 federal agencies are Bureau of Alcohol, Tobacco, and Firearms and Explosives, and the FBI, which are branches of the DOJ. All right. So Overall discovery picture. Second purpose of this declaration is to provide this court with additional information concerning the discovery that has been produced to the defense, including timing, volume, and nature of these disclosures, so that this court can make a more complete understanding about the overall discovery picture. One of my responsibilities as counsel is to supervise, consult, support with, provide direction to other members of the team. Two of those members of the defense team are a paralegal with whom I've worked for many years, including other capital cases, and a licensed attorney and their own in-house staff who specializes in management and analysis of electronic discovery. Let's see.
Yeah, but you can say what you want, but you've always got the human factor involved in this. And and we all know the human factor sometimes makes mistakes.
Importantly, discovery cannot be produced to the defense team by the attorney or Utah County Attorney's Office until the Utah County Attorney's Office has received it from the Utah State Bureau of Investigation, which I understand to be the law enforcement agency to which all discovery is sent by other local, state, and federal law enforcement agencies. So it's on a regular basis over the past 6 months, and in connection with my preparation, Paralegal 1 has provided me with materials concerning the discovery productions the defense has received from the attorney's office since the beginning of this case. Exhibits B through E are 4 charts which Paralegal 1 prepared based on their receipt, review, error checking, and processing of the discovery produced by Utah County over the past 6 months. So we're gonna skip down to the other stuff. So more specifically, the defense received approximately 12 terabytes of data on March 13th, with 6,425 folders, 613,023 files. This includes extraction of mobile devices, other digital evidence, reports generated by forensic examiners. Of concern, extractions of digital evidence appear to have been completed in September of 2025. For example, extraction of a cellular telephone associated with Robinson was completed on September 13th, approximately 6 months before it was provided to his defense. This delay corroborated by other information, and is consistent with data provided for other digital evidence contained on the hard drive. One report provided in a recent discovery production indicated that Mr. Robinson's cell phone had been reviewed September 14th. The same is true for other digital forensic data produced March 2026. For instance, one index received by the defense indicates nearly all 38 digital items listed had been completely reviewed by law enforcement by September 25th of 2025. Yet the digital images of these devices and the extractions were not produced to the defense until March 2026.
Yeah, I think that's a bit anal there. But I think that, no disrespect, but I think he or she has been a bit anal, because at the end of the day, extraction means you have taken the information from that device off and put it onto your own device. Therefore, you also need to fucking investigate it. You need to check it, and it takes time.
Yes, but when you have it, you should be able to turn it over to the defense even before you've investigated it.
Oh, okay. Sorry, I had a brain fart there. My apologies. Yeah, so extract it, just send them a copy. Yeah, got it. Right.
You extract it, you make a copy of it, and you get it to the defense so they can go through it too.
Yeah.
So it was 6 months. So they were given a copy of the autopsy. The autopsy was completed September 14th or September 16th. November 13th was when the autopsy report was given to the defense. The pictures of the autopsy were not given to the defense until March 18th of 2026.
Oh.
So it's stuff like that that is one of the reasons that I think the defense has a really good point here. And they need to get all the information. And I appreciate that they are not blaming the Utah County Attorney's Office. They are not playing the blame game. They are putting it exactly where it deserves in law enforcement. Because at the end of the day, the Utah County Attorney's Office cannot give it to the defense until they get it from law enforcement.
Yeah.
It's one of those. I see your point, but that does not really line up with the rules of evidence and discovery. If you have stuff, you are to turn it over to the defense. You are not to wait until you've gone through all 12 terabytes. You are not to
Okay,
wait
but-
until you've gone through every piece of evidence to turn it over. You want to do it that way. Okay, you go through one piece of evidence, you turn it over. You go through one piece of evidence, you give them files weekly. You don't. I have to look at the Utah rules of evidence, but you don't do this. We're going to give you the autopsy report in November, but we're not going to give you the pictures that go to the autopsy report until March. That's not how that shit's supposed to go. And I can see why the defense is pissed. Like I said, I don't like the defense, but I can see why they're pissed. And they want stuff taken care. Like they want this. It's impossible to defend a case when you don't know what you're defending.
Yeah, but at the same time, I mean, someone needs to fucking put fire under someone's ass to make sure that when you've got evidence, it's automatically copied and pasted and fucking sent to the defense. I mean, they have got a good argument there now. Yeah.
Yeah, and it's not that I like Tyler Robinson. It's not that I like the defense team, but even a broken clock is right twice a day.
But here's my question, though. This is a bit strange. Why are they sending over the autopsy report but not sending the pictures at the same time? Because they're part and parcel. I mean, that's like me sending you a half a sentence and then next month finishing that sentence off. And you like the whole month you're going, fuck.
That's like yesterday. The lawyer sending a subpoena, but not adding the complaint in it.
Yeah. And it's like other people, like where their mouth fucking engages, but their brain doesn't for a while. Yeah.
So this was just, he wrote a letter, Novak wrote a letter testifying, or, what he wants. But there's a couple of things. He has to write certain letters to people. The FBI employees whose sworn testimony we seek, Amanda Baker and Monty Swank. He has to write letters to the DOJ just based on 28 CFR 16.21. We write to request the appropriate FBI or DOJ official approve the provision of sworn testimony by the FBI employees listed below. So this is just stuff that they have to do for. Yeah.
Thank you, Bad Daza.
Hey, Bad Daza.
I mean, here's a question I've got. All right, it's like, why is this happening now? Why? I mean, if this has been going on from fucking day one, why didn't they say something earlier? Why is it
They
now?
have. But this is a motion for continuance for a hearing that's next month.
Right. Okay.
So their hearing is scheduled for February, May 22nd. So they've been going back and forth with the state on discovery and getting all the pieces of discovery and figuring things out. And now they're writing more than a month in advance, or a month in advance to say, or wait, actually 2 months in advance. Sorry.
Yeah. But
my brain's fried. 2 months in advance to say, hey, we still haven't got all the stuff. We're not going to be able to get through everything by May 22nd. So can we have a continuance for the hearing? Because we're not going to be able to get through all the evidence before the evidentiary hearing.
Yeah. I mean, looking at the number of discovery files, right, okay. Like on the 10th of the 10th, 2025, they received 83. On the 15th, they received 700 more. I mean, like, I can understand why it's taking so fucking long, because obviously they need to go, the prosecution needs to go through the documents. And once they're done, they move it on. But looking at the dates, they seem to be sort of like, you've got like from a couple of days, like 1 or 2 days, all the way up to nearly a week.
And Jeff has a point too, and this is what makes it really freaking difficult and confusing. State only has to turn over evidence they're using in the case. Hell, who's to say 100 photos of, let's say, 1,000 are blurry and unseeable? But if attorney would like to be pissed and have that sort of junk files, there's the other thing. You want all the stuff we have? Here's all the stuff we have.
Yeah.
And here's to say 800 of the 1,000 files we just gave you are completely corrupted, unusable, and blurry. But here we go. You wanted so there is a fine balancing act from the state, which is one of the reasons that I'm glad they're blaming the defense attorneys are putting the blame on the law enforcement,
Yeah.
not turning it over to the state and not turning it over to the Utah County Attorney's Office for them to go through it and figure out what they're going to use. And not, you know what I mean? Like, I'm glad that the defense attorneys are not like, well, the prosecutors haven't given it to us. It's like, no, well, they haven't given it to the state for the state to figure out what they're going to use to give it to us. So I can appreciate, at least from this document, that they're putting the blame and they're not even putting the blame so much on everybody. They're just like, hey, they're not even done analyzing some things yet.
Yeah, and by the look,
do an evidentiary hearing when the government's not even done analyzing the evidence yet.
Yeah, but looking at the dates and the amount of files they've been receiving, I mean, it's like a data dump. Instead of actually saying, right, okay, instead of actually communicating with defense, say, look, what we're going to do every 2 weeks, we're going to data dump, we're going to send you files, and basically they're going to be like this and this. But looking at this, I mean, they've been data dumping, so they've got the information from the law enforcement, and then basically fucking gone through it themselves, which they have to, and then they've data dumped. And by the looks of that, each day you're looking between 1 day up to about 5 days. So,
and here's document files 9100, image files 4800, video files 5000, audio files 61. So,
I mean, 19,600 in 2 months. What was it like?
19,612 files.
In how many months? That's 3 months there. That from the dates. Is it 3 months?
6.
Oh, sorry, I didn't see those down at the bottom. Right. So in 19,612 in 6 months. Yeah, they were data dumping. So basically, once state was finished with the files, they just data dumped.
Which is what they're supposed to do. There's just a lot of data.
Yeah, and the thing is, if law enforcement are fucking dragging their feet, and then state has to do their due diligence on these files, technically, law enforcement.
Sorry, you're getting bored, Roy.
Yeah.
Sorry, you're getting bored. I'm also trying to keep Spawn on track, because I understand why Spawn is focusing on certain things, but that's not how this particular phase of the system works. So it's, wait until microscopic or lab microscopic evidence only produced enough for one test and none left for the defense. Motions will be flying. Happens all the time. Yeah.
You see, that's not making any sense right there.
What?
Number of pages of page duration, 61. I mean, yeah.
So document. So this is one document, but it's 69 pages.
They were definitely
one file could be 1 page. One file could be 80 pages.
Yeah.
They all could vary. And it's not just getting the information, it's reading it. And it's not just reading it. It's reading it and actually comprehending it. And when you get a 60-page document, you have to read it more than once to like.
Well, there's your answer there. Law enforcement sends it to, they're dragging their feet. Prosecution fucking receive it. There's your proof. Like you say, like one document can be fucking God knows how many pages. Out of 14,000 documents, you got 61,000 pages. You can't do that over one day.
I mean, then that's total. That's total. So
yeah. Fucking hell.
And these were all compiled by the paralegal. List of law enforcement agencies producing discovery to the Utah State Bureau of Investigation as of March 26th. American Fork Police, ATF, BYU Police, Cottonwood Heights, FBI, Lehigh Police, Linden, Lone Peak, Orem, Payson, Provo, Salem, Salt Lake City, Salt Lake County Sheriffs, Santa Quinn, Saratoga Springs, Spanish Fork, Springville, St. George, SBI, Statewide Information Analysis Center, Utah County Attorney's Office Investigations, University of Utah, UT Crime Lab,
and there's your
Utah County Sheriff's Office, Utah State University Police, Utah Valley University Police, Washington County Sheriff's Office.
And there's your disconnect. There's your problem.
That's a lot.
Yeah, there's your problem.
Well, they're all giving their information to the SBI, the Utah State Bureau of Investigation. So they're not all giving they're all coordinating with SBI and turning their stuff over to SBI. SBI is giving their stuff to Utah County Attorney's Office, and then UCAO is giving their stuff to the defense.
Right. So all these police departments, are they part of that one area, or is that state? Are they all part of the state? Because that to me looks a lot.
I'm not sure where like Utah State University and Utah Valley University are. UVU is where this happened at. So this one is where it happened.
Yeah.
I'm not sure where Utah State and BYU are in relation to UVU. So it's
well, there's your answer. There's your problem.
Shocker.
Yeah, there's your problem. Why it's taken so long. There's the answer right there.
Yeah, but they're not asked. They're not, and the defense here is not complaining that they're taking a long time. The defense never was like, "Hey, we're mad that it's taking a long time." They're just simply saying we need more time before this hearing to go over this. They're just petitioning to the judge saying, "Hey." It's like having a doctor's appointment before your test results are back yet. There's no point. You're not going to get the best care if you go to a doctor's appointment with no test results. Like it just doesn't make sense. So they're going to the judge and saying, we need to push this back. You said it was tentative to begin with, and you just wanted to get it on the schedule to get it on there. It was tentative. We don't have all the information. We don't have all the discovery. We don't have everything. People are still working on stuff. We need to push it back. Nowhere in this document did they ever say we're mad at anybody or this is not right. They never were mad. They never appeared to be mad at the prosecutor's office or law enforcement. They just simply said, this is taking way longer to go through than the time we have on the calendar. And we just can't. There's no way in hell that we're going to, layman's terms, there's no way in hell that we're going to be able to get all this done before May 22nd. Can we have more time? That's it.
Which is a justified response.
Yeah, which is completely justified, which is one of the reasons that I agree with the defense in this. I just simply wanted to compare certain headlines and dispel conspiracy theories and rumors that headlines with what this document actually was asking for and said. Well, like, nowhere is this a bombshell document.
No, I mean, like I said before, when it comes, here's one thing people need to take to the bank and fucking bank this. When it comes to newspapers, they will put headlines out there to get the attention. It's just like sure. other things, like other people as well. They will do something to get the attention, and like it could be there could be 10% truth to what they're saying. However, it's just fucking attention seeking.
And that is true. But you know that people believe that the mainstream media has our best interest in mind. I know that the mainstream media is full of absolute crap and only has their wallets in mind. With that being said, when I heard bombshell new documents, nothing that has been uploaded in the past month is a bombshell document. This is not a bombshell document. This is a typical run-of-the-mill, hey, we need more time to go through all the files we have, and we have more time. This is not a bombshell. In no case would any lawyer with any sort of common sense ever consider this a bombshell. This is standard. This is typical. This is normal. They're asking, but they have to show the judge why. They have to provide the judge with case law, with evidence, with reasons. And part of the reasons is the ballistics, and part of the reasons is the DNA. That is not bombshell. That is, they're still working on it. We don't have it. We can't make heads or tails of it if we don't even have it.
Yeah, that's why I don't read the newspaper, especially those freaking, I mean, like, you need to take that with a pinch of salt, unless you got factual fucking evidence to prove what the headlines are factual. Yeah.
Yeah.
Fucking.
It is just like, this is just it.
Yeah, like, I understand. I mean, like, now, yeah, I do apologize if I fucking waffled on.
You came in like a balls to the wall.
Yeah, like a
So,
freight, as I usually do. So my
as you
apologies.
usually do. But it was like, slow your roll. We're talking about that only to dispel the headlines and actually say what is in this document. Because in my opinion, be it I'm not a lawyer, but y'all have seen for the past 2 years, I read legal documents. I have read thousands and thousands of pages of legal documents. Some more bombshell and energetic and entertaining than others. This is, as far as legal documents go, pretty boring and run of the mill. The only thing that made this document anywhere near interesting is looking at what was actually said in this document about the ballistics and the DNA compared to what the headlines said that this document said. That was the only thing that made this document even close to a bombshell, is that people lied about it.
I mean, here's the
Came
thing.
in like a wrecking ball.
Yeah,
Are you Miley Cyrus?
No, I mean, no. Wait, what? You fucker. No, here's what one thing I do want to say. One thing I have noticed, okay, and I'm going to use you as an example. Your thumbnails and your titles are more on point than some of the newspapers, because the biggest problem with newspapers is it's all about the fucking money. It's all about the views. Now, this document here is just basically like one side saying, "Hey, look at the watch. We need time." Whereas they fucking turn around and say, "Oh yeah, this document is this." No, yeah, I get it. I'm on point now.
The only thing that might be quote unquote bombshell is this is what they request. It is requested that copies of the following materials be provided to the defendant.
Yeah.
So case files, documents replied on and performing testing, SOPs, the STR database, CODIS searches, STR frequency tables, which is the STR is the DNA testing for pulling multiple people's DNA from one sample.
Do you quick question for you? Over in the United States of the Americanese, do you have a look at me like that? Anyway, do you have don't look at me like that. Do you? I didn't do. Look, I haven't done.
It's your question. I can't answer it if you don't ask it.
Right. Okay. Stop. Right. Over here in the United States of Great Britain, right, we have a independent body called the Ombudsman. Right. Basically, it's an unbiased body that can't be infected by either side. Do you have the same over there when it comes to these type of cases? Like, you know, because the files are it's taken too long for the evidence to be sent. Is there an independent body that can sort of like mediate and say, "Hey, look, this needs to be done"?
No, the judge.
It's just a judge, right? Got you. Okay.
The judge. Right.
That's a shame, because in having an independent body like an ombudsman, where they can actually, you know, being unbiased, and they can fucking go through it, and then it would actually help.
Did you let's Sniper Hunter back in if I can? Did you permanently time him out? Or
no, 300 seconds. I saw it and I was like, "Fucking Gail, what you?"
5 minutes. What you do is you click on it and you say timeout and you change it to like 10 seconds. So you go into so whoever did it, or when you see it, so you go view deleted message or put user in timeout again, and you change it to 10 seconds. So, and then 10 seconds later, it'll be done. So all you have to do is go in, and I changed it to 10 seconds. It's fine. And it
Yeah.
happens, Gail. It happens all the time. I timed someone out a long time ago in somebody else's chat because the little, when she was like super little, I think she was like 8 months old at the time, she grabbed my phone and I went to grab it back from her and I thumbed and accidentally timed somebody out who said hi. Like, and it was like, whoops, didn't mean to do that.
Well, you've got another 30 seconds because 3 of us done it at the same time.
Y'all, just one person, please.
Oh,
One
shit.
person. So in Snipe Hunter, you can come back in after 30 seconds. We changed it to 10 seconds, but you know, and
Yeah. This is a very interesting, I mean, from a perspective of non-Americanese, this is a very, very interesting and polite response from a defense or from a side in a court case. I'm quite surprised that there is actually fucking professionalism exists over there. I mean, this is a polite way of saying, hey, fucking what the fuck,
Yeah, they're part 2, a second request for discovery with respect to other areas of forensic discovery, firearms and tool marks. We have no reports, case files, protocols, proficiency tests, analysis of reviewers, CVs of analysis reviewers, developmental internal validation, data regarding the FBI's anticipated comparative bullet analysis or its anticipated lead composition analysis. When and if the work is completed, we request these categories if discovery be provided. That right there, that is not, that does not tell me the defense said that the DNA or the bullets don't match. That's not what the defense said. So these headlines, man, this is one of the reasons.
I mean, if it had been if it had been a Welsh report, it would have been fucking different. Just saying.
Latent fingerprints, shoe impressions, question documents, other forensic evidence. So,
Question of interest: have they already got the statement from him?
Probably. They just they won't show it until either an evidentiary hearing where it's presented and or trial. A lot of this stuff will not come out until trial. And that's the thing where a lot of people are like, let's see the evidence. It's like, that's not how this shit works. Tell me you've never watched a court case without telling me. But all these people who are like political pundits and talking heads on every platform of social media who have millions and millions of followers who have never watched a fucking court case in their life, let alone read a legal document. And it's like, tell me you've never been a true crime person who is obsessed with file watching like Mo, Snipe Hunter, Heidel, Broken Baker, Nick Starro, like these people who literally watch trials every day, or the thousands of people who sit in law and crime and court TVs, case or chats every day and just watch trials. It's like, if you ever did that, you will shortly find out that this and getting everything up front in the media and just wanting answers from the public and the public wanting answers is not how this shit works. Like, it's not how this fucking shit works. Like, I'm sorry, I hate to break it to you, y'all, but that's not how this shit works. Like,
I'm just
free at last. You're not pathetic. Jesus.
No, I'm just very surprised of like the complete difference between what I've experienced with American law and lawyers and in full, and then seeing and hearing about this. This is like a complete 360. I mean 180. It's like this is the way to conduct oneself. I mean, this is fucking a nice document, if I may say so. The newspaper, I'm ignoring that because they're fucking idiots anyway.
Yeah, I just did that because back when I first started my channel, I literally used to bring up headlines and fact check the media. We'd bring up headlines, we'd compare the same topic from 3 or 4 different sources, and then we would actually read the bill or the law or whatever we were talking about in question and fact check all the media. Because that is, we would do that. So this is what I do. I take the headlines and I say, well, that's not actually what this document says. Here's what this document says. And that's how I got started.
Can you do me a favor? Can you send me the link to that Daily Mail thing? I'll do some research on it and then I'll get you some feedback, get you some research done on it.
I can in a little bit.
Yeah, especially on the person who actually wrote it.
And then I gotta go. So, so this is just a declaration of Elizabeth Johnson, who's one of their experts, and that's it. So that's all that this document has. And I did find this, which we will go over in a different time. I did not read through the entire thing. I was looking for specific things in there, but we can do a separate stream on it. A simplified guide to firearms examination.
Oh,
so
my God.
It's only 17 pages, but I found this document.
There you go.
In a web search. Yeah. So we will go through a little bit more. And Spawn, I will invite you back sometime. Maybe next week.
Thank you very much. I really do appreciate it.
Maybe next week to specifically talk about that document.
Yeah.
And that topic as in relation to more about what these headlines and why these headlines were so absolutely freaking ridiculous to me. Because
I mean, it's like I was saying earlier on. Okay, there are just like in the United States, you've got like news channels like Fox and CNN and all that, right? They all want that freaking oomph, that headline. But when it comes to over here, we've got multiple newspapers. We've got the Sun, we've got the Guardian, we got the Independent, we got the Daily Mail. There are a lot of newspapers over here, and they've always been like that. And to be perfectly honest with you, in the last 15 years, in the last 15, 20 years, I haven't read newspapers because they're all full of BS.
Mm-hmm.
It's
the
basically.
Only reason I brought up the articles is because I thought they were BS, and what I do is I fact check articles, and I try to bring a little bit of the facts to what is being reported in the mainstream media, because I think the mainstream media is full of shit, no matter if they were on the right side, the left side, or they're appearing to be neutral. Generally, they are out for their own pockets, and it's just no matter what you do, and they're out for clicks. And
it's just like the newspaper. To give you an example, the newspaper Independent was actually set up to be independent from all different newspapers, so it had like an unbiased opinion. However, within years, it turned into the most nastiest fucking newspaper you could ever come across. But I don't want to go into it. But yeah, the Daily Mail, unless you see 100% factual.
Sorry.
Unless you see 100% factual proof, I'm not going to say anything. I
didn't do it on purpose.
Yeah, no. You see factual proof, don't believe it. Unless they put factual proof in there and they show you evidence of what they're saying, what the headline states, then just take it with a pinch of salt.
Which is why we read the documents, because even when you get a headline that tells you what you want to hear, generally it's not telling you everything. It's cherry picking the information that tells you what you want to hear. It's not telling you the good and the bad. And I just tell it like it is, because I don't like the defense, but I agree with them in that document that we just read. I 100% agree with them that if you don't have all the evidence and all the discovery turned over to you, it is going to be impossible for you to defend your client, whether I like your client or not. A fact is a fact. It's going to be impossible to defend your client from the evidence that the state is going to present when you do not have the same evidence.
But I think the problem with this, I mean, I do think it was a good idea for them to bring this up, because I think looking at the amount of police departments and God knows what else on that one list, 28 freaking different departments, no wonder it's taken its time. There's your problem.
Yep, but it's not, and the defense did not even complain about the amount of time. They are just simply stating, due to the amount of time it's taken, you put this hearing on the schedule, we need to push it out. And that's it. Nowhere in there I saw headlines, bombshell new document, nothing in that to me was a bombshell.
Mm.
Having read thousands of documents, not being a lawyer myself, but for having this channel for 2 years, yesterday or April 1st was my 2-year anniversary on YouTube.
Oh, so mine was 17 years.
So having my channel for 2 years now, I have read a lot of legal documents.
Yeah.
That is far from what I'd consider a bombshell document.
Yeah, that's one thing I like about you. Ever since I've known you, and I'm really humbled by this, is that when you go through the documents, you are very specific. You are to the point, and you don't veer off the topic unless I'm with you, and then it's like a fucking rag doll. Anyway,
I'm like, fun. Focus.
yeah,
Focus.
yes, exactly. And you know what I'm like? I'm like a tiptoeing around China in the China shop, but I do get to the point. But the thing is, you are very meticulous when it comes to these documents, and that's one thing I really like, because you've actually taught me a lot on these by reading these documents. And when we do discuss certain documents and we've had discussions, you are quite informative. And I'm glad that you understand that when it comes to newspapers, you just take them with a pinch of salt. And I'm glad that you brought that up, because it's good to hear someone from a different country criticize the newspapers over here, whereas we would criticize CNN, which is fake news.
I criticize everybody.
No, but you do it professionally. You do it well.
I don't discriminate. I criticize everybody equally. If you put out information on the internet, you put yourself on the internet, you should be open to scrutiny. And as long as it's respectful, everybody should be open to being corrected. And if you're wrong, you're wrong. Like, but there is a difference between being corrected and just being a blatant liar and saying that the defense said that the bullet didn't match is not what the defense said. And we went over that multiple times. But for those of you who just skipped to the end of the line, the Daily Mail's headline of the bullets didn't match according to a new bombshell document. Not true. That document was not a bombshell by any stretch of the imagination. And the ATF's test was inconclusive. And the FBI currently has the fragments and are retesting and doing other tests on the fragments. And
the only thing I'm concerned of is because once these fragments are being manhandled by different departments, is that when they do get to the FBI, there's a possibility that they are too far damaged or too far from actually getting any evidence from. However, that's just a thing that just popped into my head. But let's see what happens. I mean, this motion is quite professionally written. It's well said. It's not pointing a finger at anybody, except it is in a way. But looking at that list of 28,
so much we don't have
28 departments. That's fun. And no wonder it's taken freaking so long. And then they're getting file dumped on as well. I mean, they're getting 1 minute they're getting 63 freaking files, then they're getting 700 dumped on them a couple of days later. Of course, they're going to be fucking
Either way, I do have to get going. I have us set up to redirect over to Nick Starro and his Slightly Buzzed show. So y'all go tell him that I sent you and I said hi. And I will see you guys on the next one. Monday will be a members only live stream, Monday afternoon. So we shall see how that goes. But I will see you guys on the next one. Have a great day. Bye.
Yeah.